Welcome, everyone. My name is Andrew Cohen. I'm the Associate Dean for Research at the James E. Rogers College of Law and the Director of the William H. Rehnquist Center for the Constitutional Structures of Government. I'm delighted to welcome all of you here tonight for a Constitution Day conversation with Honorable David Barron, U.S. Circuit Judge and former acting head of the Office of Legal Counsel in the United States Department of Justice. The William H. Rehnquist Center on the Constitutional Structures of Government was established in 2006 at the University of Arizona's James E. Rogers College of Law. This nonpartisan center honors the legacy of Chief Justice Rehnquist by encouraging public understanding of the structural constitutional themes that were integral to his jurisprudence: the separation of powers among the three branches of the federal government, the balance of powers between the federal and state governments, and among sovereigns more generally, and judicial independence. Tonight's conversation is titled The President's Lawyer and the Judge, because Judge Barron has served in both of these roles. He was appointed to the United States Court of Appeals for the First Circuit in May of 2014. He graduated from Harvard College in 1989 and Harvard Law School in 1994. From 1989 to 1991, he worked as a newspaper reporter. After graduating from law school, he clerked for Judge Stephen Reinhardt on the United States Court of Appeals for the Ninth Circuit and Justice John Paul Stevens of the United States Supreme Court. He then worked as an attorney advisor for the Office of Legal Counsel of the U.S. Department of Justice from 1996 to 1999. In 1999, Judge Barron became an assistant professor at Harvard Law School, a full professor in 2004, where he worked until he rejoined the Justice Department as acting assistant attorney general for the Office of Legal Counsel from 2009 to 2010. As we'll discuss further tonight, that is the division of the Department of Justice which provides legal advice on important constitutional questions that arise within the executive branch. He then returned to the Harvard Law School faculty in 2010 and worked there as the William Green Professor of Public Law until he was appointed to the First Circuit Court of Appeals in 2014. He is joined in conversation tonight by my wonderful colleague, Shalev Roisman of the James E. Rogers College of Law. Please enjoy this I'm sure to be extremely fruitful and interesting conversation between Professor Roisman and Judge Barron.
Hello. So welcome everyone. Thanks so much for joining us, and thank you for the introduction. So we're really excited to have Judge Barron with us tonight. This evening for those of us in Tucson, this later in the evening for Judge Barron and everyone on the East Coast. And it's kind of a remarkable event for me personally. Judge Barron was, as Professor Cohen said, was once Professor Barron, and he was the first professor that I met in law school. I believe we watched a documentary about eminent domain during orientation, and that was in 2005. And he was the head of my section and was just a deeply influential influence on me in my career. And he also, in that section, was Professor Albertina Antonini, another member of the faculty here at the University of Arizona. And the year before in his section was Professor Andrew Woods, also a member of the University of Arizona law faculty. So you have quite a contingent here in Tucson, and we hope to get you here at some point physically. Obviously, you've had a very distinguished career, as Professor Cohen was saying, and I just wanted to start today with your time in the executive branch, and then I think we'll transition to your current role in the judicial branch. And so first, can you just tell us what the Office of Legal Counsel is and why you wanted to work there back in 1994?
Sure. Well, thanks, Sheila. First, I just want to thank you for the invitation and for the introduction. You're making me feel old that there's that many people who are on the faculty now that I once taught. But it makes
me feel old too. So.
Yeah, not as old as me. But it's great to be here, and I'm sorry that I can't be with you and everybody listening in person. But I came to the Office of Legal Counsel as a young lawyer right out of clerkship in the last years of the Clinton administration. And what that office does is decides legal questions for the executive branch. And Shalev knows this well since he worked in that office as an attorney advisor himself. And the basic proposition is that there's a litigating branch of the federal government, which after the government has done something, is there to advocate for the government. But before the government acts, it has to know whether what it's doing is lawful, because under the Constitution, the president has a duty to take care that the laws be faithfully executed. And so to carry out that function, he needs people to advise him on what the law is and whether an action that he wants to do is lawful. And in the early years of the government, that was a function carried out by the Attorney General. And the Attorney General would write legal opinions much like a court would do. And he had a very small staff, and it was always a he. And then over time, the Department of Justice grew and grew. And the growth in federal criminal law in particular meant that the Attorney General of the United States really wasn't in a position to do the kind of legal analysis on a day-to-day basis that the government of the United States needed, the executive branch needed. And so he delegated that function to what became the Office of Legal Counsel. And it's really an arm of the Attorney General, and it issues legal opinions and gives legal advice to the executive branch about what agencies can do, what executive branch actors can do, and most prominently, what the President of the United States can lawfully do.
Great. And can you tell us just a little bit about kind of who decides whether to ask OLC something rather than asking any other branch in the government, and why do they choose OLC when they ask them a question?
Yeah, you ask a really good question, because if you just think about it practically, you might ask, why does anybody ever ask for legal advice in advance? After all, if they're going to say yes, then you're just going to go ahead and do it as you hoped. If they're going to say no, then something presumably that you wanted to do, you can't do. So there's this fundamental question of why would you ever ask? And then if you were going to ask someone, why would you pick somebody that is independent enough from you that they'd be more likely to say no than somebody who wasn't independent from you? And one of the really remarkable features of the way we've organized the executive branch and the culture of law in the country is that, notwithstanding those very practical reasons to think the president might just want to act and executive branch actors might just want to act, and then if they get in trouble, they can clean it up later, that's really not how it's ever worked. Instead, there's always been quite a demand on the political and policy actor side for answers to questions that they have about whether they can act. And there's a variety of reasons why that's so. One is the political culture, which makes it politically costly to act unlawfully or with a perception that you're acting unlawfully. Another is an internal felt obligation of government officials that they have a duty to act lawfully. And so they like to do that. And then a third is that their policy goals often don't track law very well. And their sheer desire to accomplish those policy goals leads them to want to pick the approach that's least likely to get into legal trouble, because it's most likely to not get tied up in court, to get struck down. So there's a variety of incentives for asking questions. And one that's, I think, least known is among the reasons they sometimes ask for answers is because they want to be told no. And that's partly because there's sometimes high political demand on them to do things they don't want to do. And a convenient reason to not do it is if a lawyer is telling them legally they can't do it. So all of those various incentives go into the mix of wanting an answer to a question. And given the reasons that I'm positing for ever asking the question, you can imagine that it's not very helpful then to seek out that answer from somebody where you know you're going to get whatever answer you desire. Right? Because the whole point of asking the question, when it's motivated by the kind of concerns that I'm talking about, is to get an answer from somebody who you actually think is giving you a real answer about what the law is, rather than just what they perceive you want the answer to be. And so from that perspective, they have their own reasons to want an answer from somebody that's a little bit more distant from them. So rather than asking the White House counsel, rather than asking the person who's their advocate and has to defend them in court when they do something wrong, they have an interest in asking somebody who isn't in an advocacy role and isn't just a political advisor. And out of that notion, I think, is born the desire for an actor who performs a function like the Office of Legal Counsel does. And that's pretty much what leads to the questions. In the practical, on the ground sense, it's general counsels of agencies that ask the question, and it's the White House counsel that's directing a lot of that business to the Office of Legal Counsel.
Great. So that's a very helpful, I think, broad overview of kind of how questions are funneled to the Office of Legal Counsel and also why it kind of exists in the first place. And so let's talk about just a concrete example. So imagine the president decides that it would serve the country's interests, foreign policy, defense policy, to use military force abroad. But the president doesn't have a statutory authorization to do that. And so the president asks OLC, do I have the legal authority to use military force here? Can you talk a bit about how does OLC answer that question? Where does OLC look for the answers to that sort of question?
Well, there's a variety of different ways it comes about. I mean, there's a couple of things to just keep in mind. One is, it's rare that the way it actually happens is the president wakes up one morning and thinks, can I use military force? And then calls over to the White House counsel, and White House counsel calls over to the Justice Department. What do you think? It's usually born out of an actual circumstance, right? With an actual set of factual predicates. And usually there is a fair amount of, if you're doing your job well in the Justice Department, a fair amount of pre-knowledge that something is likely in the offing, and you begin to think about it. And further, it wouldn't make an enormous amount of sense, just like it doesn't make much sense for any legal decisions to be made just by a single person. The executive branch is a huge entity with all kinds of different interests within it. And so one of the tasks of the process of making a legal decision on something as consequential as that is figuring out what is the process by which the question will be framed and then answered. Who gets input into it? How will that input be produced? And that starts to bring in a whole range of actors, including the National Security Council, the legal advisor to the National Security Council, the legal advisor to the State Department, the general counsel to the Defense Department. All will be working that problem jointly. The thing that confounds what I'm describing as a very deliberative process is time. And another thing that confounds it is secrecy. In almost all national security issues of exigency or perceived exigency, there isn't much time, and there is at least a felt need for operational secrecy. And that will have consequences for how the executive branch will go about running a process to make sure the right question's being asked, it's understood what the question is, and an answer that fits that question is provided, whether it's yes or no. Just to give you an example, this is early in our history, before there was an Office of Legal Counsel, but when there was a president and a Department of Justice. The Attorney General in the prelude to the Civil War under James Buchanan was a man named Jeremiah Black. The question was, in the face of secession, could the president use coercive force? And so President Buchanan didn't want to answer that question for all kinds of reasons, both his own ideology, his own partiality towards the slave South, his own political concerns. But eventually it came time where he did want to know the answer to that question. And so he asked that question to Jeremiah Black. That's a pretty consequential question, right? Probably as consequential question as you could ever get as somebody giving legal advice to the president. And just to give you an understanding of the dynamics that work, Black understood what kind of question he was being asked and was sufficiently concerned about it. He made the president write out the specific questions for him that he wanted answered. And there you can find that document where you just see the actual questions set forth by Buchanan written out. And then I think he gave him 7 days to answer it. So it's that kind of dynamic. And something like that to this very day is happening, where a question's asked, well, if you're a good legal advisor, well, what do you really ask me? What do you really need to know? When do you need to know it? Who needs to know it? How broad is the question? How narrow should the question be? How narrow can it be? All of those type of things. Once that's kind of framed up, there is a body of precedent within the executive branch that the Department of Justice treats, and the Office of Legal Counsel treats as kind of its own case law on these questions. There's obviously Supreme Court precedent to the extent that it touches on these issues, which it often doesn't. There may be lower court precedent to the same effect. There may be international law dimensions to a question like that, which then international law has to be consulted, treaties and the like. So full range of materials, but probably the species of law that matters for the executive branch, that's a little bit unique to it, is its own quite extensive body of precedent, much of which is published, but not all of which is.
Great. And so I think you've touched on some of this, but you're also, as your example, I think kind of suggests, you're one of the foremost experts on the president's constitutional war powers. And you wrote what I think is the best, or certainly I consider it the best book on the Commander-in-Chief Clause, Waging War. And it gives a really detailed history of the president's use of force and the relationship that the president's Commander-in-Chief Clause and power, and Congress's ability to tell the president how to wage war. And I just wanted to ask, the book is really in a lot of ways just a history of what's happened. And I wanted to ask, why did you think that telling that history is so important? What role does history play in understanding these sorts of constitutional questions?
Yeah, well, the motivation for the book came actually before I went back into the government the second time. And it was driven in part by while I was still teaching, a legal contention that was coming out of certain opinions from the office I used to work for, the Office of Legal Counsel, regarding the president's power to wage war. And the claim was that in war, the president cannot be restrained by statute, that his power of commander-in-chief is essentially absolute. And just as a scholar, that struck me as a surprising claim. But when you dug into it, it also wasn't a claim that really had been deeply considered. And it was a little bit of like a lot of things in these areas where you kind of imagine what the law must be, and then you go look for it, and it turns out, like Justice Jackson said long ago, that there's really no there, as you expected there would have been. So that became a project to figure it out. And at the time, I thought history would be useful to answer the question, just in the way it is if you use an originalist bent to try and figure out an answer to the Second Amendment, or is New York Times versus Sullivan correct? And if you have an originalist perspective, you might look at history for that, or the way separation of powers questions are considered often by the Supreme Court today, in which they want to know what was the practice of the branches. And so I was very much motivated from that perspective. After I left government and when I decided to write the book, I really was less interested in using history for an answer in that sense. And I came to think that what was most interesting about it was, to some degree, a more sociological or legal cultural understanding of how our separation of power system works, how dependent it is on individual people's judgment, how dependent it is on the culture at the time about expectations about how much the president can or should do, about how trusted the president is, about how careful the president is. And those types of concerns, how willing the lawyers in the executive branch are to take their job seriously, how much they feel caught up in the moment of the exigency itself. All of those types of concerns seem to me much more interesting, particularly after having worked in government, and much more part of the story of how our actual constitutional system works than I had thought was fully captured in some of the ways it was discussed. And so the book really tries to be narrative in that sense, to try and convey in the moment exactly those pressures and those tensions, and how dependent it is on the character and judgment of the people who are in the positions to make those decisions.
Okay, and so the answer to those questions isn't just looking at the Constitution where it says Commander-in-Chief. That doesn't answer
Yeah, right.
all the
I
hard
didn't
questions.
think you couldn't get them. And even worse than that, it's not even looking at the whole history of the country for a clear answer to it. Because there are certain deep points that I did think came out of it, which is that absolute claims to authority tend to be both less the norm than I think our most cynical takes on things suggest they are, and also much less effective than people who are attracted to them sometimes think they will turn out to be. And I do think that an understanding of the story of our separation of powers suggests all that. But one of the really difficult things, particularly when you're talking about national security powers, is whether the right way to think of the story is one in which the degree of restraint and constraint is foregrounded. That the best telling of our history is how much a separation of power system endures, notwithstanding, centuries of people who had the chance to try and break from it. Or is the better story, look how much of a fig leaf it turned out to be. Look how much power shifted to the executive. Look how much unconstrained, uncontrollable authority there is. I think there's ways in which you can assemble the history to tell either story if you're motivated enough to do so.
And I wonder if there's a really fascinating discussion about Exparte Karen, the kind of story behind that I think encapsulates the kind of dynamic and unsettled relationship you're talking about between Congress, the president, and the courts. And I wonder if you could just tell us a little bit about that story as a kind of concrete encapsulation of government lawyering and judging in a really kind of high stress moment for the country.
Yeah, well, so the story of what they're often referred to as the Nazi saboteurs, it's coming at a time when the war is really in full bloom, World War II, and it's not at all clear which way it's going to go. And the Nazis had sent specially chosen figures to come over to US shores in submarines and to get very close to the coast. I think it was in Long Island was one drop off and Florida was another. And they would emerge from the submarines and hit the beach and take off their uniforms, switch into civilian clothing, and then melt into the US population to carry out sabotage, effectively, terror attacks. They were going to blow up a department store in New York. They were going to blow up train depots, or train tracks, various factories. And it was quite a serious thing. There were aspects of it which turned out to be more Keystone Cop than the Germans had intended. They picked people who had some ties to the US as the people would be the saboteurs. And at least one of them had an old girlfriend in the US, and his first action practically when he got to the shores was to call her. And they were eventually apprehended before they had done real damage. And the question, once they were apprehended, very much resonant with the early days of what we refer to as the war on, was referred to as the war on terror, right after 9/11, is, well, what do you do with these, quote, enemy combatants who have now been seized? Of course, in that setting, this was during a declared war. Congress had declared war, as it hasn't done since World War II for any military conflicts. And the question is, do you treat them as criminals and put them in our law enforcement system? Do you treat them as invading armed forces, as if they had parachuted in? And if so, how do you deal with them? You hold them in the brig? Do you try them for war crimes? The president, Roosevelt at the time, was quite determined that they should be tried as war criminals, and that they should not be in the civilian justice system, and that they should be put in military commissions. And that precedent, the Karen precedent for military commissions, was used in the early days of the second Bush administration in the wake of the attacks of 9/11 and the response to it, as to how to handle the detainees that were picked up in that conflict, who were then described as enemy combatants quite controversially. And were put in a military detention and then subject to the military commission. So that was kind of the genesis, and a whole bunch of complicated questions arose out of it. If they're put in military detention, does he have the power to do it? By what rules can he use it? Can the Supreme Court assert habeas jurisdiction over it? And this was all in the United States that these people were being held. One of them, I believe, was a US citizen. Ultimately, the court did decide that it had jurisdiction to hear the case, and quite a dramatic set of events followed from them taking jurisdiction. The president was committed to trying them for capital crimes in the military commissions and having them executed. And I think in the light of history, looking back, there was in no sense a fair process in the way that we would think of it for civilian tribunals today. It went to the court, and the Supreme Court decided to approve the president's authority to try them capitally and use a military commission to do it. They issued an opinion that effectively said, what the president's going to do is okay by us, and we'll issue our actual opinion explaining it later because of the rush of events. Well, unfortunately for the court, when it came time to write the opinion approving what they had already approved, Chief Justice Stone ran into a problem, and he started to think that some of the statutes that Congress had passed for organizing military justice were not very consistent with the procedures that the president had used and that the court had seemingly blessed. And it wouldn't much do to issue an opinion after the execution saying that it wasn't legal. And so Stone was quite concerned and circulated that concern in a memo to his colleagues about the problem. And then there followed quite a fascinating internal discussion on the court about how to handle the problem. And among the things that the court was fighting over was whether or not the president should be able to disregard a statute in the name of his war powers as commander-in-chief and just organize the military commission as however he wanted, no matter what the statute said. And for a time, it looked like that view was going to get traction on the Supreme Court and that the opinion would say just that. But among other people, Justice Hugo Black, objected vehemently to that notion, as did others. And they ultimately did not endorse such a notion, and through a complicated set of paragraphs, reasoning their way through why the statutes weren't as much of a problem as Stone was first worried that they were, they did uphold the actions of the president, but they did not endorse that claim to power. And that decision in itself and the way it plays out, to me, really encapsulates the, I don't know if it's Janus-faced is the right word, understanding of our separation of powers and the way the law has developed. On the one hand, the president got what he wanted. And the court was, you could say, willingly complicit in what he wanted. On the other hand, there was an assertion of habeas jurisdiction early on that the president didn't want. And there was the watchful eye of the court throughout the whole proceedings. On the other hand, the president was making a claim to disregard the statutes, and his Solicitor General had argued in court that he had the authority to do that. And when he said that in court, if you read the proceedings, it's as if the Chief Justice practically leaped over the bench to say, do you really mean to say that you want us to approve that he can disregard a statute? At which point the Attorney General immediately said, no, I don't, you don't need to decide that question here. And the court, aware of how dangerous that proposition would be to endorse, chose not to endorse it. So I think that kind of mix, and then back of it all are the exigencies of the actual fight against the Nazis and the injustice of the procedures used in that particular proceeding. And it was all that history sort of was the backdrop when the question of military commissions came to the Supreme Court some, I don't know, 60 odd years later in the Hamdan case. And fittingly enough, the justice who wrote that opinion, my old boss, Justice Stevens, was himself a World War II veteran. And one of the really striking things about his opinion is how much he treats the Exparte Karen case as basically bad law.
I think that's a great sort of summation of the executive branch lawyer perspective and then its relationship to the judicial branch. I have a lot more questions about the executive branch, but I think I'm going to table them for now so that we can move on to the next kind of major job that we're talking about, which is your role in the judiciary, which is also a pretty, important and interesting job, I think. And so after your time at OLC, so you work there at the end of the Clinton administration, then you go to Harvard and you're a professor, and then you go back into the government under the Obama administration and run OLC, and then you leave to return to Harvard Law School. And first, why did you leave OLC to go back to Harvard?
Well, one thing is I would have lost my job if I'd stayed too much longer because they put a limit on your leave. I don't know if there's how many students who are thinking about balancing career and family who are listening in, but the reality of the job in DC, which I loved, is also my wife also had a job in the executive branch at the Department of Homeland Security at the time, and we had 3 very small children. And it's a really difficult pace. It's a lot of time in places where you can't really talk to anybody else because it's a lot of national security stuff. And it's a very demanding job. It's exciting, but it's also wearing. And so I think a combination of both needing to get back and thinking maybe it was time to get back, both led to the conclusion. I was also an acting official, which means I was not the actual nominee. And the woman who was nominated, Dawn Johnson, who's a wonderful lawyer and is now the acting head of the office and had been when I was there as a young lawyer, her nomination was pending at the time. So it was a sort of confluence of events as to why I went back to teaching.
Okay, and so you go back to teaching, and you're teaching, and you're teaching your classes, you're running a center, or a program rather, and then in 2014, you become a judge. And I guess before you get there, this may seem like a weird question, but I just wonder, you had a pretty good job. Why did you want to become a judge?
Yeah, I don't, it's I think true of most people in their careers. Certain jobs, when people ask, do you want to do it? You think really hard about it. I'm not so sure would I really like that. Other times people ask, do you want to do something? And without even thinking about it, you've already said, yes, I'd love to do that. And why that is not entirely clear. I know for me, I had 2 judges that I had worked for early on after leaving law school, Judge Reinhardt on the Ninth Circuit and Justice Stevens, who I admired a tremendous amount, had a big influence on me in the way they combined, I think broad thinking about legal questions with really specific, detailed thinking, and in a way that seemed to be giving something to the country every day. I also really did love my time working in the Office of Legal Counsel as a young lawyer. And it is a kind of quasi-judicial role in the sense that, and I know there are reasons to doubt this sort of self-professed understanding of people in that office as to whether it's true or not, but you perceive yourself to be trying to give the right answer to the question and that you're actually being paid for that purpose. And it's fairly hard to find people who are willing to pay you for that purpose. Because why would they? But that was a job like being a clerk to a judge where that was the case. And being a judge is a lot like that too. Being a faculty member is to some extent, but it's a little bit different because it's not so much a job where you're supposed to give an answer to a particular problem. As a professor, the way I used to think about it is if somebody raised something in class that was not in the readings, that had not really been considered, had never been said by anybody before, and was really interesting, a good professor seizes on that comment and tries to spend some time on it. As a judge, if somebody raises a point that's really interesting that nobody ever mentioned before, that's not in any of the papers, was not written in any of the briefs, a good judge tends to say, let's not talk about it because it's not part of the case. And so it's a very different attitude towards the specifics of a dispute, which is the bread and butter of what judges do and what executive branch lawyers do versus what academics are supposed to do, which is to rise out of the minutia of that. And so those, I'm attracted to both of those sides, but I think I missed the specificity of legal decision-making while I was teaching. And so that was a bit of a pull when the opportunity came to be a judge.
Okay, and I think we touched on this a little bit, but in the executive branch, the constitutional interpretive methods seem to rely on like internal OLC precedent, you were saying, and sometimes it relies on historical practice because you don't really have judicial precedent that answers the questions directly. I wonder if now that you've been a judge for 7 years, are there particular ways that you approach constitutional questions or other hard legal questions that's different, that it is a different approach that you take because you're a judge rather than being at OLC or rather than being a professor?
Yeah, it's interesting. I sometimes wonder, and I don't know that there's a clear answer to it, and you might ask your law students this if you're teaching a class on executive branch lawyering ever. Who do you think is more constrained? A judge or an executive branch lawyer? Of those two, who will feel more constrained? And if so, constrained by what? And I think they're just so differently positioned. I mean, on the one hand, a judge is constrained by nothing in the sense that they're completely independent in a way that an executive branch lawyer has an immediate boss who could fire them, who could call them in the office and yell at them, who can write them a nasty memo and say, all these terrible things are going to happen, who can influence them in advance. I mean, all these different ways in which a judge completely independent from all that, or almost completely independent from anything like that. On the other hand, the office of a judge is constrained by the existence of being on a court, the fact that you're subject to being directly overruled, the constraints of the reality of the record, the obligations to be following just what's in the briefs. Well, the executive branch lawyer, there are no briefs. There's not even an advocate on the other side usually, right? There's just the person asking the question and you answering it without really knowing what the opponent of the position would say. You're just having to imagine for yourself what that is. So in those sense, they're just totally different institutional structures of decision-making. And I think the one thing I did take away from my time in the executive branch that has stayed with me on the bench, or a thing that has stayed with me, is that there is a lot of risk of deciding something that has not been thought through. And it's a very simple point, but it's very easy to forget. And you can forget it as a judge, you can forget it as an executive branch lawyer, but reminding yourself that the law is almost always more complicated in our legal system than you think it is. The dimensions of the problem, the unthought about aspects of it, the unintended consequences, the ways you can be missing something, the hazards of a decision that's not really been considered by people, that you're the first one to really think about it, are greater than you will anticipate. And so that, I think, has that probably in a certain way, as a good executive branch lawyer, that self-protection and making sure you don't sign off on things that you would really regret. But it stays with me as a judge just because of the, importance of what judges do when they say what the law is.
Great, and I think this brings up something that I was going to ask about earlier, but didn't. But it's a question kind of about when you're acting inside the executive branch. As we said, a lot of the time things are not decided or not reviewed by courts, but sometimes they are. And I wonder, did that make you feel better or worse? So on the one hand, it means you can be told you're wrong, right? Because the court's going to review what you do. On the other hand, you're not the final decision maker. And so if you're wrong, someone else will tell you, and it's not really your responsibility. How did you kind of think about answering questions that you thought would be actually judicially reviewed rather than answering questions where there is not going to be any judicial review? And just for the generalists in the audience, the reason some things aren't judicially reviewed are that the court doesn't answer every question. There has to be a case or controversy with injured parties. And so like whether or not the president can go to war is not something that a court is going to answer. So there's a lot of stuff courts won't answer, but then there is stuff that they will.
And there's things they don't know are happening.
Right.
To the extent some things are done secretly, but it's just not known. Well, there's something, some people have suggested that when the executive branch is making a decision about its own powers that it knows won't be reviewed, it has a special obligation to be wary of taking an expansive view of its authority. And that when it knows it's going to be taking a position about its authority that will be reviewed, there's no similar extra level of need to be constrained because it'll be done in full public view. It'll be explained to people and the courts will have a chance to challenge it, just like all kinds of action that occurs in the world. The tradition I grew up in the executive branch really didn't take that bifurcated view. It was instead, you look at all questions the same, which is that you're supposed to be doing your best understanding of what the law is, whether it's going to be reviewed or not. And that means it's as expansive as it is, and it's also as narrow as it is, depending on your best understanding of what the law is. But that's a much debated question.
And that makes sense. And I think it's just a hard role issue, I think, coming from inside the executive branch that there's no, settled answer on. So I wanted to ask you a little bit about hard cases. So I know in my constitutional law class, we discuss how, a lot of controversial constitutional issues, abortion, substantive due process in general, even Commerce Clause or federalism issues, the justices often seem to divide along what seem like partisan or political lines. And one way of explaining that is that, well, it's just politics. These are just politicians in robes. Another way of explaining that is there's no kind of settled answer. The text doesn't answer it. There isn't another definitive legal source. And so the justices are just using their judgment. And once you're using your judgment, then it's probably hard to not be influenced by your kind of moral, policy, political views, whatever. And I just wonder if you have a view on kind of what's the right way to think about that. So as a judge, when you're dealing with a question that's hard, it's just genuinely difficult, and you have to decide like what the law is. How do you do that?
Yeah, well, it's both the challenge of it and the difficulty of it. I mean, one thing, and this isn't to avoid answering the question, but just to give some context, which I think is helpful. The Supreme Court rightly looms very large in our imagination of our legal system, but it's a piece of it. It's not the whole of it. It's not where most cases are decided, how most cases are decided. And it's organized in a way that's unusual compared to a lot of courts, particularly to all the lower federal courts and the courts of appeals and the federal district courts, in the sense that its docket is chosen by it. So for those of you familiar with courts of appeals procedure, one way to think about it is the Supreme Court is always sitting en banc. They always know when they come to hear the case how the other members of the court thought about that case when they selected it. Well, in the courts of appeals, that's just not true. We have a mandatory jurisdiction. We have no say over what we're going to hear. And so when we get a case, we're not sitting en banc. We're just getting the case because we have to take the case. And that does, I think, change, at least from my limited experience with the less than 10 years I've been on the bench, there is a different mind frame of a court when it's just getting its steady diet of cases it doesn't know what they're going to be, and month after month they come in. You clerked for a Court of Appeals Judge Slevin, you know how this is. The mindset of the court is not divided in that way. There's no reason it would be. It's much more in the mode of how do we collectively figure this out, because we got so many other ones that we also have to do, and we're working together. When the court goes en banc, as courts of appeal do, it's a different setting. At that point, there's been a divide on the court. Now, when it comes to hear the case, there's already been some understood division. Not always, sometimes it goes en banc for different reasons. But that's a different enterprise of collective decision-making than most courts are engaged in almost all the time. And yet the Supreme Court's organized in a way in which it's almost always deciding things from that starting point. So that's just a difference in the way, and again, the way the institutional architecture can affect decision-making, how it can contribute to public perceptions of how justice is dispensed with and decided. So that's a piece of it. Difficult questions are just, as they come named, difficult. And for me, I think the hardest ones are statutory questions where there seems to be a real ambiguity. It's very hard to know what the prior or the tie-breaking principle is supposed to be in a situation like that. It's not what I think. There's a great exchange that's recounted, I forget the name of the case, in the Administrative Law Casebook that I'm now an editor on. There's a passage from it, and it's exchanged by Justice Stevens and Justice, I think it's Justice Stevens and Justice Scalia, maybe Justice Barron and Justice Scalia, but I think it's Justice Stevens. And it's a fight over what the meaning of some statutory term is in an education funding case. And Justice Stevens takes the purpose-based view. Justice Scalia says he's taking a textual-based view, and they have a fight about it. And I believe Justice Scalia accuses the majority of, you're just picking the purpose you want to serve your purpose. And the rejoinder that I really appreciated from the majority is, let me just assure you one thing, I truly don't care what the policy on this is. I care what the legal answer is, but there's no policy preference that I have here that I'm enacting. And I think that's often true for judges. I think the public understandably is skeptical of that in a certain range of cases, but in enormous number of cases, it's just true. You are committed to the legal system. You're committed to trying to do the job right, but that makes it difficult, actually. That's why it's hard, because when you're looking deep into you, it's very hard to see what is there.
Right. I suppose in some ways, if you were just doing politics, it'd be very easy to just figure out the answer. There wouldn't really be hard questions.
Yeah.
So kind of related to this notion, I think you kind of raised the idea that people picture the Supreme Court when they're thinking of the judicial system. It's obviously the most high profile court in the country. And, I think it's just true that it's become more politicized in recent years. The appointments of justices has been highly political, and there's increasing movement and suggestions for reform of the federal judiciary. So some of it takes the form of proposing term limits for judges or justices. Some of it takes the form of adding justices to the court. That's sometimes called court packing. And then other reforms focus more on just disempowering the judiciary. So there's an increasing sense, I think, particularly on the left, that the judiciary is taking on too much power in our system. And it kind of, harkens back to this notion of the counter-majoritarian difficulty, which was a term coined by Alexander Bickel, which is basically the idea that when the court strikes down an act of Congress or of the president, it's acting against the political will, because Congress, the president are politically accountable, courts are not. And so it's serving a sort of anti-democratic function. And I just wonder, how do you respond to the arguments these days that basically say we should take power away from the courts, and that's our way to help strengthen our democracy? Is that true, or how do you even think about those sorts of suggestions?
Well, so there probably was a time in a different role where I would have been more directly engaged in trying to think about what the answers to them. I think for me, the way I think about it now is from the perspective of, given where I am, is how does one do that job well? And I think that means you've got to be very aware of any ethical concerns. You've got to be aware, are you contributing in your off-bench activities to the polarization of our legal culture, or are you trying to take steps to suggest that there's ways in which moments in which there's been a more shared legal culture have been attractive ones? These things are difficult because, of course, there's been times in our history where a shared legal culture did a lot of violence to people and a lot of exclusion. And it was people who were willing to disrupt that consensus that made the legal profession a much more attractive, open profession than it once was. But I think from my perspective, I just try to think of it through that lens. And then I think, through the way we write our opinions, through the way we treat each other in our opinions, through the respectfulness we give arguments, the thoroughness of the way we try and go through them. Those are all small ways, but I think there are ways in which over time they can contribute to a sense that the aspects of the legal culture which are the opposite of what you're describing, if there is an opposite, something that's not quote politicized, something that's not polarized, something that, for lack of a better word, captures some sense of legitimacy in the minds of the public. Not that it's not there now, but just that, it's a relatively fragile thing. It's, I think, an important thing. And so I guess I just am focused, I think, like many judges are, on, what are we doing in our daytime that's sort of contributing to a sense of trust and confidence in the legal system rather than the opposite.
Well, we are glad that you're doing that. I think we want to open it up to questions, but I guess I just had one last topic or question I wanted to ask you about, which is just
one last thing, so that just made me
Yeah.
think about, that just occurred to me, and you may experience this. It's a funny thing about law and the way law works, at least from my perception in American life. On the one hand, it is very intuitive and natural for people conversant in American law or interested in it or have views about it to think of it, as we sometimes say, from an external perspective. In other words, you attribute to those people engaged in judicial decision-making a whole bunch of non-legal motives and explanations for their actions. And that is a very strong feature, always has been in American life. And to some extent, relatively healthy, because it's a way of disciplining judges by keeping them in check in certain respects, attentive to the fact that people don't just have, immediate trust in what they do, and that they have a suspicion of what's really motivating it. All of that, you see it present today, but it's been true from the very beginning of our history, straight on through. But there's an equal intuitive sense from people of what you might call an internal perspective, that what judges should do, what we would expect if I was in court in front of a judge, what people do actually expect when they're in court in front of a judge, is that's not how they'll be deciding the case. And it's very, I notice it myself, interestingly, I'm in chambers working on opinions, working with other judges, all of whom seem to be operating from an internal perspective of trying to do it well. And then I'll sometimes be teaching a course in the afternoon, and I'm describing these cases, and you fall into an external description of what's happening when you're trying to explain to the students the divide on the court or what was motivating. And it's, one of them you would think has to be wrong because they're not consonant with one another. On the other hand, they're both such a part of our legal culture. And I suppose it's hard to prove one is true or the other is true. But I think that tension is sort of definitely true. At certain points, the balance tips one way or the other in ways that are concerning. But I think you can't pretend that it's all one or all the other or ever has been.
I think that's a great way to end that part of this session. And it's the sort of sentiment I try to convey in my classes, but I've never put it so well. So thank you for that. I'm glad there's a recording of this. So let me move on to the Q&A from the audience. I'm going to just read them. And so I apologize if I don't read them as elegantly as I would otherwise. But so the first is about OLC, and it says that Judge Barron mentioned incentives for a president to consult an independent Office of Legal Counsel, and many of which seem to describe cultural norms and expectations. And in a political world where many cultural norms are no longer followed, would an opinion from a less independent Office of Legal Counsel give legal cover to further norm-busting behavior? So,
yeah, well, one thing I think that people in that office, at least when I was there and when I was a young lawyer, felt strongly about, and I think it's true of judges also, was that there was a kind of custodial ethos in working in those places, precisely because you knew that that office, if it did decide things in a way that were treated as not on the level, it would be very hard to convince people in the future that when it did something, it was on the level. And that if that started to happen, the whole, so the jig would be up in a certain sense. And I think that the sort of thrust of that question, that's true for all legal decision-making that's supposed to be done in a way that's based on something internal to the law that has integrity as a legal decision, that's a challenge all of actors engaged in that face. I guess I would say that it's interesting to me, notwithstanding all the controversies, and particularly in the last decade or so, and the interest in the Office of Legal Counsel that's arisen as a consequence of those controversies, that it is still looked to for legal opinions in the executive branch. There's still very little thought that trotting out a memo from the White House counsel in support of your decision is going to count for as much as it would from the Department of Justice. And I haven't seen much indication that that's changed.
And a question that kind of follows on this is, you present OLC as an important, or at least a meaningful constraint on presidential power. But my impression, this is the question asker, is that OLC opinions say yes far more often than they say no. Am I mistaken about that? And either way, can you give a couple of concrete examples of OLC constraining the president?
Yeah, so well, there's one thing which you will be perhaps rightly skeptical of this as an answer, but it happens to be, I think, accurate, which is there's all kinds of legal advice giving from the Office of Legal Counsel going on all the time, of which the published works of the Office of Legal Counsel is a fraction of its actual legal advice. Most of it is not published, and it is in oral telephone calls or short memos. And if you think about it, it would be really surprising, politics being what it is, if when the executive branch had an idea for a policy that the lawyers told them was illegal, they decided to make that known to everyone. It's much more likely that when they've decided to do something and the lawyers say, yes, it is legal, they would like that known. And so a feature of the published works of the Office of Legal Counsel is that they tend to be the works in which the president turned out to be right. That's not an accurate reflection of how it happens, in the sense that often there are proposals in which he's told that he's wrong. They don't go forward. Now, that's not because they're so scared of the Office of Legal Counsel. A lot of times the idea was sort of half-baked, or was floated, or they weren't really sure of it. But nonetheless, the office's decision to say, no, that's not going to work, or that raises concerns, or we have our doubts, has a very large constraining effect. Then are there sort of high-profile decisions where the Office of Legal Counsel has said no? Well, in recent years, probably the most high-profile of them all was, of course, with respect to the surveillance powers of the government, where my former colleague in the Office of Legal Counsel said no on a decision to approve the continued surveillance, which set off a real crisis in the Justice Department. So, but if you go, in the Iran-Contra, the early stages of the Iran hostage crisis, you can find even published opinions from the then head of the office saying no to various things. I believe there was a very famous opinion from the Office of Legal Counsel about indexing for inflation tax rates, and that was a famous no. So there are very high-profile no's that have been issued over time, but I think that captures less the way in which the constraint operates than the more informal no saying that I'm talking about.
Great. And this one goes back to your judicial capacity. So how much caseload pressure does your court operate under? And how, if at all, does that affect your decisions on the merits? So some studies have suggested that very busy courts of appeals are significantly more likely to affirm district court decisions. Is that true in your experience?
Well, I have two data points. One was when I was on a very, very busy Ninth Circuit Court of Appeals when I was a law clerk. And I think the judge that I worked for was not known for affirming. So that limited experience suggests to me that, at least with respect to that judge, I don't think the pressure had that effect. Our court is not challenged in the way that some of the other circuits have been. So I have not felt that. In fact, everything is relative, but compared to the time pressure of being an executive branch lawyer, there's nothing but time when you're on the Court of Appeals relative to that, even though, it's our obligation to decide things as fast as we can.
Great. And then I have a question from Professor Andrew Woods. It says, hello, Judge Barron.
Hey, Andrew.
So great to see you again. I have a question about legal education. There's much talk about how legal education should change to include more skills training, different skills training, to be shorter, to be more apprentice-like. And I wonder if how your experiences away from the academy have influenced how you think about the future of the JD. So you taught, then you left for DC, then you taught, and then you left for the bench. Did either career change affect your views of the JD more than the other?
Well, I think so. I think four things popped into my mind, Andrew. It's a great question. One of them is sort of against, not that this is the sort of direction your suggestion should go, but pushing back a little bit on the idea of more skills training, experiential apprentice-like. And that is that I think there's a tremendous value of students entering into law, learning about the legal ideas themselves and the history of law as its own discipline. And I think it's quite vital for the profession to grow in a healthy way, that the lawyers entering into it have the chance to reflect on law and understand law from that perspective, and not to see it just as a tool, not to see it just in an instrumental way, but to understand it in a broader sense of what its role has been in the history of the country and the history of the world and the history of human freedom, both negatively and positively. And that's very hard to do outside of an academic setting. And I think we can easily undervalue the importance of that task of legal education. But on the other hand, there are dimensions of practice that are absolutely critical and that are very hard to convey in the classroom. That clinical education certainly does it. But I know when I came back from my second time in Washington, and when I teach now as a judge, there are two dimensions of practice that I don't think law schools quite capture and don't introduce students to as much as they should. One of which is what it means to be operating within an institutional environment in providing legal advice. So we're very good at teaching you legal analysis and how to do legal analysis, but anybody who's left school and then worked realizes that a lot of times what you're being asked for is dependent on your mastery of the legal analysis, but they're not asking just for the content of it. They want a whole bunch of prudential judgments, a whole bunch of assessments of the institutional situation. If we did this, what would then follow? Who's going to be likely to object to it? Who needs to be notified about this, given what you're about to advise? That whole range of questions, which I think is a lot of what makes being an actual lawyer so fun, is really hard to capture in a classroom setting. And I don't think we do a great job of introducing people to that dimension of lawyering. The second piece of it is we do a lot on the legal profession and legal professionalism and the rules of the legal profession, much more than was done in earlier days. And we do a fair amount of reflecting on the way law can bring about change or frustrate change from being brought about. I think we do relatively less on getting law students to reflect on their own professional persona and character and what it means to have one. And I really was struck by my second time in Washington by how much that matters, how many different types of professional character there are, which have their own merits and demerits, and how you, whether you like or not, end up developing when you get a reputation as the type of lawyer who is cautious, is creative, is aggressive, is not, a whole range of different things. And that's on you, that you inhabit that persona and character. And where does it come from? Why are you like that? How did you get to be that way? Why are you that way? Why aren't you some other way? That, I think, we don't really spend a whole lot of time finding ways to introduce law students into being intentional and thinking about that aspect of their professional development. So those are just dimensions of legal education that I think there could be relatively more focus on. Then I think the last one is just ensuring, and I get the sense, and you would know this better than I would, Shalev and Andrew, from the students you teach, just ensuring that the consequence of legal education is to leave students more enthused and excited about the professional choice they made by coming to law school rather than less. And that's, I think, a bit of a challenge. I mean, I think there are all kinds of aspects of legal profession that are exciting and empowering, but there are all kinds that are demoralizing for students. And the more law schools can find ways of leaving law students feeling energized, that they can build a meaningful life for themselves as a legal professional, that to me, that's in a sense the main task of the law school experience.
That's great. And so I have one last question, I think, that got in just under the wire, or got to me just under the wire, which is back to OLC. And it relates to some of the stuff you were talking about in terms of prudential judgment and the like. And it asks, when called on to analyze the legality of the executive's proposed actions, does OLC consider and weigh in on the potential consequences and impact of that action? Or is it a more purely concerned with whether something is legal or not?
So here's an answer which I don't know how satisfactory an answer it is. In the wake of legal realism, which is the world that we all are inhabiting, because once it comes to you, it's there. There's always the specter that the right legal answer has to have a consequentialist dimension. If it's not a practically workable solution, how could it be the right answer in our society as a matter of law? So there's that sense in which you probably would be doing a poor job of legal reasoning if you weren't attentive to that dimension of legal reasoning. But that's different than saying that the legal analysis is just about the consequences that will follow from it. And there are ways in which a certain set of consequences could easily be understood to be no part of the legal decision, right? They're within some range of potential consequences that follow from it, which are understood to be all contemplated by the legal outcome that is the proper one, rightly understood what the law is, right? That those will just be possible consequences, and they're not supposed to influence the decision because they're just possible consequences of what the law is contemplating. Now, how do you know which of those two things is true, right? And in certain settings, depending on the nature of those consequences, it can look in retrospect, how could the legal decision maker not have thought that through? And in other settings, the focus on the consequence how could they have put so much weight on the consequence rather than following the law? And the remarkable thing is, it can be almost the exact same decision. Both critiques could be made of it, particularly in high exigency circumstances. Why were you giving into the exigency? The whole point of our system is that the law is supposed to be a constraint. And how could you be so focused on the formalities of law when there's this exigency? What, are you people crazy? And that's just endemic tension in legal decision making.
Thank you. On that note, I just wanted to say thank you so much for joining us. I know that I learned a ton, and I know that, and I'm sure that the attendees did as well. And thank you to the attendees for joining. And if we were all here, we would give you a big round of applause, and so we can do this weird Zoom thing. But thanks for joining us, Judge Barron, for this Constitution Day conversation.
Thank you, Shaleb. I really enjoyed it.
All right, take care, everyone.